Great. So as we're waiting for people to come in, I just will share some logistical overviews for the event this evening. My name is Joanne Kilgour. I'm the Executive Director of the Ohio River Valley Institute, and I'll be your moderator this evening. This webinar will be recorded so that anyone who wasn't able to attend live will be able to access the recording after the fact. We're also enabling a live transcript function. At the bottom of your screen, you should see a button that will enable you to use closed caption for accessibility. The format this evening will be a moderated panel discussion, but we will leave time at the end to address your questions. So please feel free to use the question and answer function, and feel free to pose questions as we move through the panels, and I will document them and be prepared to raise them during our Q&A, or you can wait until we get there and then pose your questions then. So we will keep track of everything, and feel free to let us know if you have any questions moving through the panels. Okay, well, it's now my honor to introduce our panel for this evening. We're joined by Professor Jamie Van Nostrand, who joined the faculty of West Virginia University College of Law in July of 2011 and serves as the director of the Center for Energy and Sustainable Development. Professor Van Nostrand came to the West Virginia University College of Law from the Pace Law School in White Plains, New York, where he served as executive director of the Pace Energy and Climate Center. Prior to his transition into law school teaching, Professor Van Nostrand had a successful career as a partner in the energy practice group of two large law firms based in the Pacific Northwest. In his 22-year career in private practice, he represented energy clients in state regulatory proceedings in 8 Western states, as well as proceedings before the Federal Energy Regulatory Commission. Thank you so much for joining us this evening. We're also joined by Robert McKinstry Jr. Mr. McKinstry has practiced and focused on environmental law since receiving the first joint degree from Yale Law School and its School of the Environment in 1970. A co-founder of Ballard Spahr's Environmental and Natural Resource Group and its Climate Change and Sustainability Law Initiative from 2001 to 2007, Mr. McKinstry also served as the Maurice K. Goddard Chair in Forestry and Environmental Resource Conservation at the Penn State University School of Forest Resources. He served as counsel of record representing a group of 18 of the leading climate change scientists who submitted amicus briefs to the US Supreme Court supporting petitioners in Massachusetts versus EPA, and represented clean air companies before the United States Court of Appeals for the DC Circuit and the Supreme Court in EPA versus EME, Homer City Generation, and Michigan versus EPA. Thank you so much for joining us this evening, Mr. McKinstry. And finally, we're joined by Professor Miranda Leppla. Professor Leppla is the director of the Environmental Law Clinic within the Milton and Charlotte Kramer Law Clinic at Case Western Reserve University School of Law, joining the faculty in 2022 to start the new clinic after over 5 years, serving as the Vice President of Energy Policy and Lead Energy Counsel at the Ohio Environmental Council. At OEC, she led the energy team's campaigns and served as lead counsel in all energy litigation matters, and represented the OEC as well as other nonprofits at the Public Utility Commission of Ohio, the Ohio Power Siting Board, and courts throughout the state of Ohio. Prior to that, Professor Leppla was in private practice for several years, where she focused on litigation, natural gas utility issues, toxic torts, False Claims Act litigation, and utility scale wind farm permitting. Thank you so much for being with us this evening, Professor Leppla. All right, so with that introduction, I'd like to start off by setting the stage for our audience and getting a sense of the context that's necessary to understand the decision in West Virginia versus EPA. So Professor Van Nostrand, I'd like to start with you. Could you give us a brief overview of the case and what actions led up to the Supreme Court decision on June 30th?
Sure, Joanne, thanks. West Virginia versus EPA, this case goes all the way back to the Obama administration's adoption of the Clean Power Plan in August of 2015, which regulated greenhouse gas emissions it required a 32% reduction in greenhouse gas emissions by 2030 from 2005 levels. And West Virginia led the challenge to that plan. It was argued before the DC Circuit back in September of 2016. It was West Virginia and 24 other states. Before that decision was issued, the US Supreme Court issued a stay and said, we're not going to allow EPA to take any actions to implement the Clean Power Plan until the judicial appeals have been resolved. Following Donald Trump's election as president in November of 2016, the White House issued an executive order pretty much saying, directing the EPA to revise or rescind the Clean Power Plan. So that led to the Trump administration's adoption of the Affordable Clean Energy Rule in June of 2019. That, in comparison to the Clean Power Plan, instead of a 32% reduction in greenhouse gas emissions, would have achieved reductions of about 0.7 to 1.5% by 2025. That was appealed by a bunch of environmental groups and states. The case was captioned American Lung Association versus EPA. So that was a challenge to the Affordable Clean Energy Rule argued in the DC Circuit in October 2020. January 19th, 2021, the DC Circuit issued a decision invalidating the Affordable Clean Energy Rule and then also reversing the repeal of the Clean Power Plan. And that was appealed by West Virginia, filed a petition for cert on October 29th of 2021, granted cert, the Supreme Court granted cert, and the case was argued on February 28th. So it's pretty much, it's an appeal of the DC Circuit's reversal of the Affordable Clean Energy Rule, which repealed the Clean Power Plan. So that's the context in which the case made it to the US Supreme Court and was argued on February 28th.
Thank you. I also will just note that I invite the other panelists to interject if you would like to follow up to any questions directed at one of your colleagues. Next, Professor Leppla, I'd like to ask you if you could just tell us a little bit more about the history of the Clean Power Plan and how it relates to this case.
Sure, and I was smiling when Jamie was talking because it's clear as mud, right? The case trajectory is a bit messy. So thanks for giving that overview for everybody. But yeah, like Jamie mentioned, this stems from Obama era regulations. The EPA during the Obama administration adopted revised regulations specific to this case under Section 111D of the Clean Air Act. And the goal really there was and the goal of that section is to adopt the best system of emissions reduction. And that was to reduce emissions from existing sources, and that was called the Clean Power Plan. So under this, the EPA determined to use these building blocks, they called them, and the first of which were heat rate improvements at coal-fired power plants, which included practices coal plants could undertake to operate more cleanly and efficiently, or really similar to other kind of source-specific things they'd done in the past. These other two building blocks were a little bit newer, and they basically involved generation shifting. And so what this means is that they would, rather than focusing on the performance of those individual level sources, the goal is really to force a shift from one type of energy source, namely the polluting energy sources like coal and natural gas, to cleaner systems. And that overall, the goal was to improve the system's carbon emissions as a whole. So while it set out, as Jamie mentioned, to reduce carbon emissions from power plants from 32% from 2005 levels by 2030, one of the things that's called out specifically by the majority's decision, which we'll get into more, but he cited Gina McCarthy, who was then the EPA administrator's comments in congressional testimony that was not about pollution control, but an opportunity for states to invest in new energy sources. So that's really what this was about, and whether or not that was legal to have a generation shifting method here that was established by the Clean Power Plan. And we'll get into this more later, but it is important to note that the levels targeted by the Clean Power Plan were hit 11 years ago. So we are far beyond that and in a much different space now. And I know we'll get into some of that kind of as we talk more about the case history.
Great, thank you. So finally, Mr. McKinstry, I'd like to ask you about the role of the makeup of the Supreme Court. So we've heard a lot about how the current court has played a role in recent decisions, and would just really love to hear why you think this case was heard by the court, given the status of the rule at issue, and what role the makeup of the current court may have played in the decision.
Like many others, were baffled as to why they took the case in the first place, since the administration was not going to reinstitute the Clean Power Plan, and it appeared to be moot, although the administration had not taken any action actually to repeal the Clean Power Plan since the court had acted. I am not sure how much the makeup of the court really changed a lot, because a stay was entered before we had the solid 6-3 conservative and 5-4, I would say, very conservative majority. So he certainly it had something to do with it, but it was such a bizarre set of circumstances where you have EPA invoking, actually the Trump EPA was the one that invoked the major questions doctrine to say that, hey, you can't use Section 111D to affect major changes in the electricity industry. And they pointed to what Gina McCarthy had said, hey, the EPA itself saying we want to transform the industry. 111D was traditionally a technology-based standard. And there could have been some ways they could have used it, and we'll talk about that later, that they could have done the same thing. And the rule itself, the Clean Power Plan, even though the ACE rule was very, very weak, the Clean Power Plan, as Miranda mentioned, was no better than business as usual. And actually a number of clean energy companies commented to EPA on the original proposal that this rule is no better than business as usual. So what happened was clearly predicted from the model. So it really is sort of a bizarre set of circumstances leading up to leading up to the decision altogether.
Thank you. So for the next phase of the discussion, I'd like to get into the decision itself, what it says, what it doesn't say, and what might still be unclear. So Mr. McKinstry referenced Section 111D of the Clean Air Act. And Professor Leppla, I was hoping you could walk us through the holding of the case and what it might mean for future applications of Section 111D.
Sure. So Chief Justice Roberts, writing for the majority, really held here that the EPA lacks this broad authority to limit greenhouse gas emissions from power plants under the Clean Air Act and under this specific Section 111D, the way that the Clean Power Plan attempted to do it, which was through this method of generation shifting. And instead, what they say is that they only have the authority directly delegated to it by Congress. Now, there's disagreement over whether this provision means that they had this direct power, but that is what the ruling held. And specifically, the Chief Justice said there's an obvious difference between a rule that leads to an incidental loss of coal's market share, and simply announcing what the market share of coal and natural gas and wind and solar and other types of generation must be. So again, this was a divided court, and we'll talk more about the dissent later. But they concluded that the EPA could not adopt these regulations that are premised upon generation shifting or substitution of fuel sources as a means of reducing those emissions under 111D. And so, I will say there are a lot of folks that when they were looking at this, even at the time this was promulgated originally, were concerned about the generation shifting method since it was a novel approach at the outset. And they had concerns it wasn't going to be held up. Some thought the EPA might just go for a very restrictive emissions approach, which they'd done anyway. But, a lot of folks were very concerned if they had attempted that direction, it would have been really costly to do that way. And so this generation shifting method at the time was actually the most cost effective and industry preferred method. And I was listening to several folks talk about that were involved directly in the litigation about how to remind us that no power companies were actually arguing against this at the Supreme Court because this was the cheapest way they could do this. So they were actually not involved in this case directly. And there was definitely some briefing recognizing this. So, some thought you could just wall this off and say the EPA went too far and just go back to the generation shifting piece, send it back to the EPA, since they'd created a crediting mechanism that pulled renewables in and covered sources that weren't traditionally like wind and solar that weren't covered by the Clean Air Act. But that's not what happened, obviously. So we've got, a major questions doctrine here that we'll get into a little bit later. But As for future applications of 111D, there are already many ways in which regulations already occurred under this provision. And the holding here, again, is very limited to generation shifting systems of emission reduction. So that's really the only thing that's been taken off the table under 111D now. There are zero carbon fuels, there's co-firing, there's carbon sequestration. Those all meet the requirements under 111D. And in fact, the Obama administration went through those when it was originally promulgating this, talked about those, but then kind of recognized that the end result of all of those methods was going to be generation shifting. And so they kind of just went straight forward and set these different types of standards that technically hadn't been done before. So I think there's a lot of ways to address emissions, even under 111D still, despite this ruling. And then, of course, there's lots of ways to address other emissions. You know, our largest segment of emissions is the transportation sector. Industrial emissions aren't addressed here. So there's lots of different ways.
Am I on? Okay. One thing that you clarified at the end, you said fuel switching wasn't okay, but fuel switching is in fact okay. And one of the things that the majority opinion said is that you can't use a cap and trade program to set the standard, which has been done was done actually under other sections of the Clean Air Act. Justice Roberts did say that you could establish your goal in other ways. So you could, but he did not say whether you could then use cap and trade, which I think you probably can. In the mercury and air in the Clean Air Mercury rule, which was invalidated on other grounds, the Bush administration had set a standard using technology-based standards and then used cap and trade to lower the cost. So you could use, for instance, carbon capture and sequestration, theoretically, fuel switching, all the things that Miranda mentioned, and then allow a cap and trade to reduce the cost. But we don't actually know that.
Thanks. So Mr. McKinstry, while we have you, there's been a couple of references to the major questions doctrine. So I was wondering if you could talk to us about what is the major questions doctrine and how, if at all, does West Virginia versus EPA change the court's approach to statutory interpretation and understanding the limits of federal regulation?
Well, that really gets to the difference between the Justice Alito concurrence and Justice Roberts' majority. I actually read that difference to say there actually isn't a major change in what the law is. Some people have said they think so, but I don't. The major questions doctrine says that if you are addressing a major change or a major issue, that you want a clear statement from Congress that you can interpret the statute in that way. The doctrine supposedly arose originally under the Food and Drug Act as applied to cigarette manufacturers, and it has been around for a while. And every so often you see it reemerge. Now, people might argue that this is a case where it reemerged, but the bizarre circumstances I mentioned in the first place make me a skeptic as to whether the majority opinion, as opposed to the concurrence, really advanced that and made it a more significant issue. Now, we'll need to see it in later cases, but Justice Alito expanded on the major questions doctrine and had an extensive discussion about when it should be used and how it should be used and how it should be applied. He was joined by only one other justice in that concurrence. So at least there appear to be 7 who aren't willing to go that far. The major questions the bizarre circumstances here are the fact that the Trump administration, EPA in this case, which normally gets deference, invoked the major questions doctrine to revoke the Clean Power Plan and then to revoke the Clean Power Plan. So the court was really, the majority at least, was really employing the rationale that EPA had used under the Trump administration to revoke the Clean Power Plan. So therefore, it could signal an expansion in the future, but I'm not sure of that.
Thank you. So Professor Van Nostrand, we have talked about the Clean Power Plan and its status, and I'm just curious if you could talk to us a little more about how the fact that the Clean Power Plan was repealed in 2019 may have factored into the court's decision in this case.
I think one of the points made by Mr. McKinstry is, no one in front of the court was really advocating for the Clean Power Plan. It had been repealed and replaced with the Affordable Clean Energy Rule. It was the Affordable Clean Energy Rule that was struck down in the American Lung Association case in front of the DC Circuit, which by implication then put the Clean Power Plan back into place. The Biden administration had made it clear we don't intend to proceed with the Clean Power Plan for a lot of the reasons that Miranda gave. We'd already achieved a lot of those greenhouse gas reductions. We're going to do something more aggressive, but that just happened to be the way the case transpired. The American Lung Association was a very expansive decision, I think, in terms of repudiating a lot of the arguments that were made against the Clean Power Plan and articulating all the power that the EPA had, pretty much validating all the legal analysis the Obama administration had followed in adopting the Clean Power Plan. So that was a very broad decision, I think, and that I think particularly rankled some members of the Supreme Court, particularly Justice Kavanaugh, who heard the arguments in West Virginia versus EPA in September 2016, and was fairly hostile to the position of EPA and skeptical that they could use 111D to use this generation shifting that Miranda talked about. And so it was, I think it was a case of particular interest to Justice Kavanaugh. The fact that the American Lung Association case in the DC Circuit went so far in giving EPA very broad authority. And the way I see it, it's kind of the stars were aligned in terms of this opportunity to really curtail the authority of regulatory agencies, because you already had Justice Gorsuch who had expressed some skepticism about the Chevron deference that's usually accorded to administrative agency decisions. Alito and Thomas had already come out pretty much saying, we need to curtail the broad regulatory authority that we're giving agencies. Chevron deference is a really broad grant of deference. Usually when an administrative agency makes a decision, the courts say, well, is that a reasonable, is that a permissible interpretation? If so, they give it a pass. And that's the standard of review that was pretty much, once you decide it's a major question, then it's a different standard, and the court saying we need to see specific statutory authority. And the clear language triggering the major questions doctrine is it of vast economic and political significance? And as Mr. McKinstry mentioned, it came from the Brown and Williamson case back in 2000. I think once the vaccine mandate case came down in January of 2022, the National Federation of Independent Business versus Department of Labor, basically the Biden administration said it was okay for employers to require vaccine mandates. Although the per curiam decision in that case did not refer to the term major questions, the concurring opinion certainly did. But that was kind of the writing on the wall that the way this court is made up, that the EPA authority under the Clean Power Plan under 111D was probably, it was in for a tough road in terms of it was seen as a fairly obscure, rarely used provision of the Clean Air Act, and it's being used for this generation shifting that Miranda referred to, whereas it's clearly a big deal. That's my short-term phrase for vast economic and political significance. This is a big deal. We expect Congress to speak directly and make it clear that the agency is authorized to do that, and we're not seeing it in 111D. So I think it's really that's the direction this makeup of this court is going. It's clearly kind of reining in the broad authority of regulatory agencies and wants the major questions doctrine. And so it's just a question is, we'll talk about this later on, I think, but agencies are going to have to really think about it. Where is the clear authority that we have to take this action? Because the courts are going to be looking very closely. Agencies are going to be fearful. Oh my God, this could be seen as a issue of vast political and economic significance. In which case, where's our clear statutory authority? We want them to uphold this on appeal. So I think it has a definitely dampening effect on agencies taking aggressive actions.
Thank you. While we have you, and because you brought up Chevron, I'd like to take us for a moment to the second question posed by Kathy Ann Kowalski in the chat. Did the court leave the Chevron case intact so the majority might be able to rubber stamp any new Trump-like regulations that would relax environmental standards?
Yeah, Chevron deference is very much intact. That case came from 1982, I think, involved a Reagan administration decision in the EPA as to whether or not you could define stationary source to include sort of this bubble concept. And that's where the whole doctrine comes in. The court looks at the two-step has Congress specifically addressed the issue? In the case of the bubble concept and the definition of stationary source, no. And then the second question is, well, is the agency interpretation one? Is it a permissible one? So it's a very deferential standard. And basically the court's inquiry comes to an end if the court can conclude that it's a reasonable or permissible interpretation. So it's, and even the court would say, well, we think there's a better one. That's not the one we would adopt, but Chevron deference doesn't allow them to do that. It says that's a permissible or reasonable interpretation. Your inquiry is over, the agency wins. And there's been a lot of resistance to that over the years. And like Gorsuch, Alito, and Thomas are pretty much outspoken on it. In terms of, it gives a lot of authority to regulatory agencies. And the perception is we need to curtail that. But no, Chevron is definitely still in play, but it's like step zero is in that analysis instead of step one, step two. Is step zero, well, is a major question involved, in which case Chevron doesn't really apply, but it's still there if there's not a major question involved. That's the way I interpret it anyway. I think this is an expansion of the major questions doctrine, I would say. So the number of cases that Chevron applies has probably been narrowed, and it's a little bit unclear as to how this is going to play out. But the agencies are going to be very mindful of, gee, are we going to get Chevron deference, or is the court going to find this an issue of vast political and economic significance and make us, apply a major questions analysis?
Although Jamie's, the discussion of Chevron and major questions is one of the reasons I question whether this is really a big deal with respect to major questions, because what was the court reviewing? The court was reviewing the action of the Trump administration, which had invoked the major questions doctrine. So arguably, they were giving Chevron deference to the Trump administration's invocation of the major question. And that's why when I said this is a really bizarre case, it's a bizarre case because of that tangled administrative history.
So while we, Mr. McKinstry, while we have you, I wonder, so there was another question posed by Kathy Kowalski that's to this point. And, to the extent that you can answer this, do you understand the major questions doctrine to be a way for the court to just ignore the justiciability requirements under federal jurisprudence?
I would say no. They reached out here to take this case, which arguably they ignored the justiciability. But the way the court got around it is they said, well, the Biden administration says it's going to repeal the rule, but they haven't done anything. So there is still a live controversy. And they can't ignore the justiciability since it's based on Article 3 and the court's power. So I would say no, but I would also argue that a lot of times justiciability is used as a way for the court to get rid of cases it doesn't want to hear, or
yeah. So coming back to some of the environmental implications, Professor Leppla, I wonder if you could share with us what authority EPA retains to regulate greenhouse gas emissions from sources outside the power sector?
Yeah, again, I think this just goes back to what a narrow ruling this was from the majority. Both Jamie and Bobby have gone into kind of the concerns about the major questions doctrines that are definitely expanded by concurring opinion, but that's only 2 justices here. So again, this holding is really centrally, limited to this generation shifting method that was specifically put in play by the Clean Power Plan. So the EPA retains all the other authority that they've had to check greenhouse gas emissions from other sources. And whether that's specifically under 111D or all of the other methods that they've got, again, this is just going to be really narrowly tailored to make sure that they can move forward on, well, hopefully, again, we'll see. To the point both my colleagues here have made, we don't know what's going to happen next. We don't know if they will embrace major questions doctrines. We don't know how Chevron deference will play into this, but again, it gives a lot of us hope. They're hoping for better regulation here and some expertise from these regulatory authorities to be able to continue to do the good work that they've done over the years to, clean up problems that we've had and clean up our climate change issues because they have retained some of that authority and they are the experts. And I know we'll get into this in a bit, but I mean, that was really the point of the dissenting opinion was that, there's just a very big disagreement here about deference from Congress and regulatory agencies, and Congress is simply not suited to be an expert on everything. They don't have the ability, even if they wanted to. No one's got that power. So we really have to rely in large part often on these regulatory authorities because they are the experts. So hopefully whatever we see come next out of our agencies will be exactly that.
Great. And you mentioned some of the opinions that were filed along with the majority. So could you talk about Justice Kagan's dissenting opinion? And, aside from what they said about not reaching out to decide the case since the regulation had been repealed, what do you think the dissenting justices would have ruled in this matter had they been in the majority position?
Yeah, and as you mentioned, the dissenting opinion really, like they said, they wouldn't have accepted this case at the outset, and they see it as a significant overreach, but not based on mootness, but rather because it amounts to an advisory opinion rather than an active controversy here for all the reasons my colleagues have mentioned, since the CPP wasn't in effect and the Biden administration had no intention of bringing it back. So that's kind of where they were sitting on all of that component. But regardless of all of that, it is pretty clear from the dissenting opinion and forcefully written that they believe the case, if it had been accepted, they would have ruled in favor of the EPA's rulemaking authority here, specifically because the Section 111D permits the EPA to devise the best system of limiting emissions, and then really concluded that generation shifting system that the EPA devised under the Clean Power Plan fit within that delegation of power by Congress when it drafted the Clean Air Act originally. And there's a lot that Justice Kagan goes into to talk about what this was at the time it was drafted in the legislative history there. She really explicitly called into attention to the fact that operational improvements at the individual plant levels would only result in these small reductions in emissions, and then it would cost a lot because they would have to shift to a readily available regulatory alternative, which meant generation shifting. So we would have probably gotten to this place. And so, her point was just because this was already occurring, the Clean Power Plan just skipped that intermediary step here and implemented a requirement to make those two building blocks I mentioned earlier move forward and reducing emissions in this more cost-effective manner by generations shifting. And I think Bobby mentioned it a little bit, but they really point to the frustration they have with the majority opinion obstructing EPA efforts from the very beginning of the Clean Power Plan. And Jamie mentioned this, the implementation was initially stayed so the Trump administration could issue its own rules, and the lower courts had never ruled on it yet. And the dissenting opinion specifically points out that had never been done before, which was very problematic in their opinion from the outset. And it, points out that the moderation of the plan really meant that market forces, like we've talked about, have already caused us to hit all of the targets that were set in place 8 years or more actually than this was set out to do in the event that this was moving forward in the way that it had been originally planned. So just really, the baseline for the dissent is really that Congress did provide authority for the EPA to do this. to make important decisions on this topic, because they look at this as a best systems of emissions regulation. And they look at the section as a whole. And Justice Kagan really goes into detail on the fact that in the dissent's opinion, this was specifically written to take into account regulatory flexibility for unknown things that will happen in the future. And I thought one of the really interesting points was she points out the intentional language that was used to do this. So, and I think, Bobby, you might have mentioned this, but she talks about the fact that they intentionally left out the word technological when they were talking about the best technological system. That is the language that was originally used to regulate new sources of pollution. And this, they left technological out of the best system of emissions reduction as part of this section 111D. And then later on, they actually repealed the word technological from the new source of power. And so when you look at that actual language, it just shows in the dissent's opinion and kind of what their reading of this was, that Congress knows what the mix of legislative and administrative actions lead to good policy, and then the courts should, rely on that. And so I think they are very strongly in support of the EPA having deference, especially on a substantive topic as important as climate change to all of us.
Thank you. We've also talked about the concurring opinion a bit. Professor Van Nostrand, could you talk about the significance of the concurring opinion that was signed by Justice Gorsuch and Justice Alito?
Yes, it's basically it provides the sort of the judicial basis in context of separation of powers of the legislative branch, enacts laws, and the judicial branch interprets them, and it compares the major questions doctrine along the lines of what's known as the clear statement rule, that we look for Congress to have a clear statement from Congress that the agency is authorized to take actions. It sort of goes back to this issue of major vast economic and political significance. There needs to be a clear statement that Congress intended agencies to have this authority. So it's just a thorough discussion of, and it's similar. There was a concurring opinion as well in the vaccine mandate case in January 2022, where the justices, Gorsuch again goes off and says, let us talk about the major questions doctrine and the clear statement rule, how they work together, and then pretty much, and goes through the history, I think, sort of going back to what I mentioned before, going back to the Brown and Williamson case in 2000, the vaccine mandate case. Look, this major questions doctrine has been around for a while. This is not a new concept. And then cite some of the facts of this case in terms of this is an issue of vast political significance, given the prominent role of generation of electricity in the economy, the fact that the economic impact statement talked about the number of power plants that would close, the impact would potentially have on electricity rates. So a lot of it's basically kind of walking us through why these doctrines should apply in this case to limit the EPA's authority. So it's basically the agency seeks to resolve for itself the sort of questions normally reserved for Congress. That's one of the lines out of the concurring opinion. So it's just an effort to really flesh this concept out. I guess probably to provide some guidance going forward in terms of when agencies should be worried about whether the clear statement rule and the major questions doctrine come into play. But again, as Bobby pointed out, it's only two justices. It's Gorsuch wrote the opinion, joined by Alito, and the other four justices in the 6-3 opinion did not go along with it.
Great. So for our next section, we want to talk about regulating emissions and kind of what comes next after this West Virginia versus EPA decision. And for these questions, I'm just going to pose them to the panel. So feel free to jump in with a response, and we can, have more than one response. But the first is, could this ruling be used as legal precedent for future rollbacks of EPA's authority or the authority of other federal agencies?
I mean, I think we talked a little bit about that already. It's kind of an unknown so far, right? It definitely could be. I think, and one, I know lots of worry I've heard from folks is that other agencies will be, this will have a chilling effect essentially on other agencies. They'll be a little bit nervous to go forward, on an aggressive action because they'll be worried they'll be stuck in litigation for several years. But on the other hand, again, and Jamie just mentioned this, we don't know how aggressively the major questions doctrine is going to be enforced, because we had a much broader opinion from the concurring opinion than we did from the majority on this. So I think it's hard to say right now. I don't know if you two have other thoughts on that.
I would agree. And I think we'll talk in one of the later questions about what some of the other authority which EPA could use, which has both case law and clear statutory authority. And I think one of the problems here also that creates greater uncertainty is there are a lot of ways in which EPA shot itself in the foot in the Clean Power Plan, because they really emphasized in the preamble, we are making fundamental changes to the electricity industry. And that's what the Trump administration picked up in the repeal. And that's really where the major question, that's where the court grabbed on this as a major question, because Congress wouldn't require a major transformation of an industry without clear legislative authority. So I agree. We just don't know. I think that, perhaps it'll send a message to be a little more careful about how you write your preambles.
Well, I think that there's also a concern that you've got a lot of new judges, more conservative judges that have been appointed up and down the federal courts and district courts, circuit courts, that are going to latch on to this major questions doctrine as a way of philosophically aligning with reining in the authority of the regulatory state, reining in the administrative state. I mean, I think there's a number of cases since the vaccine mandate case came down where recent judicial appointments have sort of latched on to, this is a way of curtailing broad authority granted to agencies and taking a closer look. Where do you get the authority for that? Make the case, this is an action of major significant economic and political significance. So it's not just how the Supreme Court's going to apply it, but how lower courts. I think probably go back to Miranda's points. You're going to be mired in litigation that could potentially be used as a basis for a decision by a district court or circuit court judge, whether that's consistent with what the Supreme Court intends or not. It's another tool that the anti-regulatory folks have to use.
Yeah, and
oh, go ahead.
I was just it was a very general comment. Just, most of us saw this coming. This has been a brewing fight for many, many, many years about what the authority of Congress is versus regulatory agencies and what deference has really been granted. So just a very general comment, Bobby. So I don't know what you're going to add, but go for it.
I was going to say many of us were relieved at how narrow the opinion was. And it reminded me as we were talking that in Massachusetts versus EPA, the Bush administration had invoked the major questions doctrine to deny the original rulemaking petition seeking to force regulation of greenhouse gases under the mobile source section of the Clean Air Act, Section 202. And of course, the majority of the court rejected that. So almost to say climate regulation alone, it's been since reaffirmed in several other Supreme Court opinions, that is intact. And the notion that the major questions doctrine would prohibit regulation of greenhouse gas emissions, I think is intact, and the court was unwilling to take that up and go as far as it might have. Many of us feared it might have gone here.
Yeah, and just one more comment on. I think that's a really interesting point, and kind of goes to the original question about, does the makeup of the court have an impact on this? And I found it really interesting how clearly, intentionally, I think Justice Kagan in the dissenting opinion was using Scalia's words as kind of one of the champions of textualism to kind of point out the irony that the major questions doctrine is being used by a group of folks who have in the past adhered more to that textualist approach. So I just thought that was a very interesting and clearly intentional, like I said, choice made by the dissent.
Thank you. So in this region where we focus, the Ohio River Valley, we have a significant amount of fossil generation, so coal and gas-fired power plants. Could this ruling disproportionately affect communities in Ohio, West Virginia, and Pennsylvania? And can the states take action based on their own existing authority?
I can jump in on Ohio at least. You know, I don't think this is going to have much of a direct impact, this particular opinion anyway. I don't know what it holds for the future. Like we were saying, we can't predict what's coming next necessarily. But, you know, as we already mentioned, all of the goals of the CPP had already been met. Their states can certainly take action on their own. There was nothing in this opinion to suggest there's a prevention of states or local, you know, governments from taking action to curtail things in a different manner other than what was repealed here or prevented here. And I think the question comes down to how this is going to be affecting our communities is really how the state legislatures are handling this, and then our local communities. And really in Ohio, we're not in a great spot here in Ohio. We've recently had a piece of legislation that bailed out coal plants, one of which wasn't actually even in our state, it was in Indiana. And we also repealed our clean energy standards. So that's our renewable portfolio standards and our energy efficiency standards. So we have a whole ball of problems at the state level that weren't addressed in any way by this opinion, and need to be, we need to do more to make the state move itself.
I'll let Jamie jump in on West Virginia, and I'll take Pennsylvania last because Pennsylvania is different from West Virginia and Ohio.
I mean, I'm not sure how this, I mean, in terms of the impact of the prospects for the coal industry, notwithstanding that Attorney General Morrissey made quite a name for himself on this, and it's seen as a huge victory for the coal industry. There's not going to be any utility in the United States that's going to be building a new coal plant just because the EPA might not be able to use 111D. So it's kind of it's a victory of sorts, but it's, you know, it doesn't do anything to overcome the market forces that are otherwise prevailing upon the coal industry. I mean, the regulatory costs, environmental costs was really not much of a driver for the demise of the coal industry. And the fact that EPA might have got its wings clipped a little bit in terms of regulating greenhouse gases doesn't really do anything to improve the prospects for coal in West Virginia or any place else in the United States, frankly.
I'll talk about two things. I just filed an amicus brief, John Dernbach and I, today supporting the Pennsylvania regulation, and I'll get into that. But to pick up on Jamie's point, actually, I've said for a long time that it's not regulation that killed coal. It's actually directional drilling and shale gas development that killed coal. I mean, people call it fracking. It's really directional drilling that basically, you know, made it feasible to develop all these shale oil, which produce a whole lot of natural gas, and you know, also develop natural gas wells. And in fact, the price of the amount of oil that came in drove the price of gas at one point down to $2 an MCF, and it requires $5 an MCF to develop even a dry shale gas well. So you know, coal is affected by natural gas. So this isn't going to make a big difference in terms of the coal industry. It may actually, but the gas industry, I think in the short term, regulation probably will increase use of natural gas because it may accelerate the shutdown of some coal-fired plants, which when you shut down the plant, it'll be more that they'll be shut down because they won't be available for use in emergencies. Right now, coal-fired plants used to run as baseload plants, and now they're really just stepping in when demand gets really high. So some of those might be shut down, but you won't have that won't affect the demand for coal significantly. In Pennsylvania, of course, we have fairly broad authority under the Pennsylvania Air Pollution Control Act to regulate, and we also have an environmental rights amendment which makes the state the trustee, which was actually one of the subject of our brief. Pennsylvania, I've filed a petition to establish an economy-wide greenhouse gas auction cap and trade program going to zero, which I think there's by 2050, which I think there's authorization for. The EQ, the Environmental Quality Board, is sitting on that, but that induced Governor Wolf to decide to join RGGI, which is the Regional Greenhouse Gas Emission Initiative, which involves I guess, is Pennsylvania the 11th or the 12th state in that? But basically, everyone in the Northeast but Pennsylvania. So Pennsylvania joins it, and Maryland's part of it, Delaware is part of it, and then all of New England and New York and New Jersey are part of it. And that will establish a cap and trade program to reduce greenhouse gas emissions in the electricity industry only. The Commonwealth Court entered a preliminary injunction against RGGI, but found there was statutory authority, but found that the RGGI auction constituted a tax, which is one of the arguments we made. That was appealed to the Supreme Court. Actually, that appeal came out of the Republican leadership in the House and Senate, as well as an appeal by one coal-fired power plant. That was appealed to the preliminary injunction was appealed to the Supreme Court, which where you would have an automatic supersedious of the preliminary injunction, but then the Commonwealth Court lifted that, and what we just submitted the amicus brief in is an appeal to the Supreme Court of the lifting of the automatic supersedious. So we'll have to see what the Supreme Court does with that. I'm hopeful that they will eliminate the supersedious, but then we still need the full case to go forward. And in addition, some gas-fired companies actually filed an appeal recently, which hasn't been answered, and they believe there probably will be preliminary objections filed to that.
So, recognizing that it's still early, we don't know what a lot of the next steps are going to be following this decision. I think a lot of environmental advocates are wondering whether there needs to be a shift in tactics or a way of reevaluating the community's approach to securing meaningful action on climate. So to the extent that we know now, is there anything that you would recommend for environmental advocates to be considering in the aftermath of this decision?
Well, I can, so I'm an academic institution now, but I can put my activist and advocacy hat back on from the nonprofit I was at before. And I can tell you that if it was us, there are different types of advocacy in different levels. There's the federal actions that this is related to. And as you heard from, I think all three of us, really, this isn't going to impact what's happening at the state level too much for the reasons we've discussed throughout the webinar. But, there's still a need for folks taking action at the federal level. I know Clean Air Task Force is going to be all over whatever happens next, as they have been with this case, and that all the folks they represent. There's still a huge need for advocacy at the state level and also at the local level. There's a lot of work going on in Ohio to try to figure out how to move forward in a state that has had a scandal-ridden controversial bill that was passed that involves, bribery of the Speaker of the House and one of our electric utilities. So things are tough in Ohio at the state level, but there's a lot of really excellent movement going on in our local municipalities. There's an organization called Power Clean Future Ohio that's doing some really outstanding work, and they just released a report that they'll be testifying on actually tomorrow in the Senate Banking Committee in DC about the costs for municipalities of climate change. And if we don't do something different, it's a huge amount that's going to land on municipalities, and goes into a lot of detail about where those costs will happen, whether it's preventative measures or after the fact measures, and how they're going to be able to deal with that. So Power Clean Future Ohio and Ohio Environmental Council are going to be talking about that a lot. And I will say at the local level here in Ohio, Power Clean Future Ohio's goal is to get folks to sign up to basically shift their energy sources toward a cleaner future. And so we're lucky to have a great tool, community choice aggregation. And we're seeing a lot of folks either joining aggregation efforts that are not just about bulk buying power for pricing now, but they're also banding together to get better pricing on clean energy. And so that's really some of the shifting that we're seeing in Ohio that's most effective right now. And really exciting when you're looking at kind of a bleak landscape at the state level. So again, that's just the state and local level. But I think Bobby probably has some thoughts. We were talking about how, cooperative federalism is really critical here. So I'm sure you've got some more thoughts on that.
Well, I think a lot of us, as we've shifted back and forth, we're looking to the states when the federal government dropped the ball, and the states have picked it up. However, I think that, I don't look at federalism as the Federalist Society does. I think that's really states' rights. I think federalism is the states as laboratories of democracy, and then the federal government coming in and protecting the states from a race to the bottom. And I think there are regulatory mechanisms which EPA can and should look at under the Clean Air Act. Still, there are petitions pending which would both seek to establish a national ambient air quality standard under sections 108 to 110. I think that's too slow for what we need to do. I think the best approach now, particularly enabled by the Paris Agreement and the various decisions under the United Nations Framework Convention on Climate Change, is to do a SIP call under state implementation call under section 115, the international air pollution, with a cap and trade backup, a federal implementation plan, which would be imposed if the states don't act, asking them to make the reductions that you need to get to zero by 2050. And that's very, very feasible, and the states could do it if they would, but that puts the floor under it. There's also other approaches under 115, under 111, but that's too slow too. So I think 115 is the way to go. Now, one additional thing about local is that what's it called now? The Inflation Control Act, Build Back Better.
Inflation Reduction Act, yeah.
Inflation Reduction Act it has a lot of mechanisms that local government will now be able to use to bring clean energy to their residents. I'm a township supervisor, and there are a lot of township supervisors say, what can we do to bring clean energy and to encourage clean energy? And I don't know if we want to get into all that. Jamie might even be better than I to do that, given all the funding mechanisms. But that will get us to 40%. To 40% by 2030. We're going to need that additional 10%. And I think the regulatory mechanisms, which throw it back to the states, really are the way to go.
Great. So we are going to open the floor to questions. I see we have a question in the Q&A from Mike Toney. If any other participants have questions, please feel free to pose them, and we'll take a queue and respond as they come in. Professor Van Nostrand, I'd like to direct this question to you from Mike Toney. Would giving the DC Circuit jurisdiction over any further litigation regarding the Mountain Valley Pipeline rather than the Fourth Circuit, which is a measure Senator Manchin says is part of the deal to move the Inflation Reduction Act forward, be a simple case of Congress making a clear statement through legislation as encouraged by the Supreme Court? If not, why would it be legally problematic for lawmakers to tell the court system how and which cases to take up?
Another good question from Mike Tony. He's a reporter for the Charleston Gazette and Mail that does a really nice job of covering energy and environmental issues in West Virginia. Some of you might be aware, in connection with the Inflation Reduction Act, there's a one-pager that was, I think it's the source of it is Senator Manchin's office, of these permitting provisions that need to be addressed in connection with that. One of that Mike refers to is the frustration that the Mountain Valley Pipeline developers have had with the fact that the Fourth Circuit keeps vacating permits and sending them back to the drawing board. And both under the Endangered Species Act and crossing national forests. And then the Fourth Circuit is using the same panel of judges. And so another piece of these provisions says it's going to direct the courts that they have to use the random system of assigning judges to cases because of the frustration that Mountain Valley Pipeline is feeling because they get the same three judges in the Fourth Circuit who keep thwarting their project. I mean, back to Mike's question, I mean, I don't think that's the kind of a clear statement really goes to the, if it's a big deal, it sort of goes back to this issue. Is it an issue of vast economic and political significance? We expect there to be a clear statement from Congress that the agency has the authority to do that. I don't think this would be that sort of a case, but it is significant because under the Clean Water Act, you can bring, and EPA and the Endangered Species Act, you typically bring those in the circuits where the projects are located. The Clean Air Act, all those cases go to the DC Circuit. So one of the things in this one page of all these permitting provisions is that we're going to carve out the Mountain Valley Pipeline and say that all the appeals have to go to the DC Circuit. I mean, Congress can clearly do that if it wants to. It's pretty unusual. It's bad politics, bad environmental policy. Congress has the authority to do that, whether it wants to do that, whether this is the case warrants that. And I think even more problematic is the other piece in there that says, circuit courts need to use a random system of assigning judges, which is how they typically do. There's three judge panels on these circuits that get randomly drawn. And in fact, in the Mountain Valley Pipeline case, the initial assignment of these three judges was through that random process, but through judicial efficiency, it says, well, let's just have the same judges keep deciding these cases. And that hasn't turned out very well for Mountain Valley Pipeline in their view. But that's even a bigger deal for Congress to tell the circuit courts how to run their business and how they ought to be assigning judges. I think that would meet with substantial resistance. Speaking of separation of powers in the legislative branch, tell the judicial branch how to do its business. But there's all sorts of interesting things in those permitting provisions. But I don't think, and back to my expression, I don't think that's an example of a clear statement, but it is something that Congress has the authority to do. They can carve out. I mean, I go back to the TVA versus Hill case, right? When the Tellico Dam was being built by TVA, and the Supreme Court in TVA versus Hill says you're killing the snail darter, you're endangering an endangered species, you're deputizing endangered species, you have to stop it. Well, they passed an appropriations rider, thanks to Senator Howard Baker, in the dead of night. And they said, notwithstanding any provisions of the Endangered Species Act, TVA shall complete the Tellico Dam. So Congress can override these specific environmental laws that would otherwise come into play. That was done in the dead of night, and I'm not sure anybody cared about the snail darter. In the case of Mountain Valley Pipeline, I think that has a lot of attention. I'm not sure you're going to be able to pass that one without anybody paying attention. All of a sudden, it's going to go to the DC Circuit instead of the Fourth Circuit. I don't know. That's interesting. There's a lot of interesting provisions in those permitting. That one page that came out of Senator Manchin's office. We'll have to see where that goes. But we'll know in the next couple of months.
Well, I mean, it's interesting. Even under the Clean Air Act, permitting decisions will go to the circuit where the facility is located.
Yeah.
It's only rulemaking that goes to the DC circuit. So it would be sort of bizarre to require permitting decisions to go to the DC circuit. I mean, you really need to increase the number of judges on the DC circuit if you start doing that.
I hope that answers your question, Mike.
Thank you. So again, please feel free to submit any questions. While we're waiting, I'd just like to open the floor to see for our panelists, is there anything else that you would like to make sure that our audience takes away from this discussion that we haven't talked about or that you'd like to underscore from our previous discussion?
One of the things, I teach a class at WVU called Legislation and Regulation, and one of the things we talk about is, why do we have these administrative agencies? And one of the big reasons is they have specialized expertise, and Congress can paint the big picture with broad strokes and delegate to agencies which have the specialized expertise, and things tend to run more efficiently by delegating the details to the agencies. I think going back to this, the major question, we expect Congress to address it. And I think the Gorsuch concurring opinion pointed out that Obama had this frustration. If Congress won't act with comprehensive energy and climate legislation, then I will, as pretty much saying, I'm going to use the available authority. And so the clear statement and major questions doctrine kind of presume, well, Congress needs to act. But we know with 60 votes necessary to pass anything in the Senate, it isn't all that easy for Congress to act. Congress is not particularly nimble. And that's one of the advantages of administrative agencies is you can recognize there are technological changes. You can move more quickly in response to what's going on in the industry. Congress can't do that. So there's a lot of reasons why we created these administrative agencies and we empowered them and we delegated this authority to them. And so I get it in terms of philosophically how this should be working. Congress needs to make these major findings, and then the agencies need to administer the acts. But in reality, we know that doesn't really work all that well. I mean, another one of the major questions case was King versus Burwell, right? When the Affordable Care Act got saved by Justice Roberts, because Justice Scalia filed a blistering dissent that says, this is really badly drafted. Congress needs to fix it. Well, we knew Congress didn't have the votes to fix it. If the court didn't save it, the Affordable Care Act was going down. So Justice Roberts figures out a way to craft this, but that was another major question. But it's a recognition that, as a practical matter, it isn't all that easy for Congress to fix these things or to address these issues. And so we empower administrative agencies to take action when Congress may be gridlocked and there's action is necessary and the agency has the technical expertise that Congress maybe doesn't. But it's just sort of a bigger picture of thinking about maybe some of the disadvantages of reining in the regulatory state like this court seems to be inclined to do under the major questions doctrine.
Yeah, I was just going to underscore what you said, Jamie, about under the Affordable Care Act case, they didn't have the votes to do it. They also don't have the expertise necessarily to get it right. And so again, that goes back to your point. That is why we have delegation and why we have, regulatory agencies that are able to do this and have the expertise to do this. The energy sector is extremely technical. It is extremely complicated. It's extremely fast-paced and moving, especially now. The technological advances we're seeing that will hopefully help us get out of this bind we're in and have made for ourselves on climate change are really rapid. And so, it's really important that we have that ability. And it is disturbing to see, even though, again, this is a narrow decision, it is disturbing to see that there is a possibility for this to go much farther in next cases.
One thing I noticed, there was a comment about cap and trade, and I will say that in the electricity industry, the way we dispatch electricity and its impact on pollution control, particularly interstate, is a very, very technical issue. And I will say that in the EME Homer City case, where EPA employed a cap and trade program as a way to what as I call, one of the problems with with electricity is that it's dispatched by least cost. So if you, it's like a whack-a-mole. I wanted to put that in our briefs, but I kept getting it taken out. I mean, you'll whack it down in Pennsylvania, it pops up in West Virginia. And so you have to really put a uniform blanket or a steel top on it. You have to put a cap that applies to everyone if you want to, and then do some pretty complex modeling to make sure that the emissions don't pop up. And in that case where you're worried about concentrations, that you don't get concentrations elsewhere. So because of that, you really to effectively control, to most effectively control, you can do it on a smaller scale. You really need a cap and trade program that applies to the electricity industry, and because of what's called leakage. The other thing is that in the case of greenhouse gases, particularly carbon dioxide, the only way to equitably distribute that is by way of an auction, because so many people use it, and that's what California uses in its program. And you can, if you have problems with low income, you can deal with that. If you have problems with particular communities, but since there are so many sources of carbon dioxide, and different industries and folks can control it differently, you really need to use some sort of an auction system just in order to equitably distribute it. And we actually made the point that no one has a right to pollute, and with an auction, then in Pennsylvania's case, the revenues go into the Clean Air Fund, which can be then distributed to communities to reduce air pollution and provide low income energy efficiency, all sorts of mechanisms like that.
I think just one more thing, just to go into, and we weren't going to go into too much detail on it, but the Inflation Reduction Act, I can't get it right either, Bobby, has some really good stuff in it. It is, it's tracking with this idea that, we already hit all the CPP goals before it was ever close to the level it was supposed to reach, and before it ever had been implemented, essentially, because of market mechanisms. And, with the gridlock we see in Congress and the difficulty we've had, the fact I was shocked that this is even moving forward potentially, because I thought it was kind of dead in the water. And so if there are ways to get this moving forward, I'm excited about it, because there are different types of grants for environmental justice. There are components in there about methane reduction investments. That's a huge problem that is not being addressed in lots of places that we are all housed in, right? Pennsylvania and West Virginia and Ohio, tons of natural gas drilling and methane emissions. So there's a lot of really good stuff in that piece of legislation. So I guess my point is just stay tuned to that, because that's going to make a big impact regardless of this decision, which is exciting if it gets through.
Yeah, and I think the provisions relating to what's called energy communities, where if you're a community that's been disproportionately hit by coal mine shutting down, or coal plant shutting down, or extraction industry closing down, the investment incentive, the tax incentives are basically enhanced, like another 10% to try to target the investment of renewable energy facilities, manufacturing facilities in those energy communities. And then as far as the just transition piece of it, you've got the prevailing wage pieces of it in there, and the requirement to involve have an apprenticeship program. Certain percentage of hours have to be with the apprentice types, so that you're addressing that issue that we're going to be losing fossil fuel workers. Those are relatively high paid jobs, and if you want to get the full advantage of the tax credits, you're going to have pay the prevailing wage and have this apprenticeship part of it as well. There's a lot of really good things in there that address issues specific to Appalachia and other regions of the country that have been disproportionately hit by this transition, the decline in the coal industry.
And just another point like that, Jamie, there's a bunch of building investment funds in here, and those are by definition local jobs. So yes, if somebody wants to build, their base and build up the communities that have been hardest hit. There's a ton of money in here for tax credits and jobs and residential efficiency, new efficient home credits. There's a lot in here that, and like I said, we've repealed our electrical efficiency standards anyway in Ohio. So that's very exciting for us, because one of the main things we used to talk about all the time was that these are by definition local jobs. You can't outsource efficiency roles and workers. So that's really exciting to see those pieces in there too.
Yeah.
Yes, and one of the other interesting things, and I'm not sure how it works precisely, is I've seen reports that you can actually sell the tax credits. And if you're a local government, if you're a church, you can't. It takes a fairly complex transaction in order to put solar panels on your roof, because they don't pay taxes, so they can't get tax credits. But if you can sell a tax credit and you're a nonprofit, then you can just do it fairly directly. I mean, it'll still require some legal work, but and for those of you who are lawyers, it'll increase the amount of legal work, and some of it'll be local.
Great. Well, I'd like to thank our panel very much this evening. Thank you all for taking the time to join us and prepare for such an in-depth discussion. And also thanks to our attendees. It's great to have you with us live. And we know that we'll be circulating the recording for those who couldn't join at this time. So again, just a big thanks. And it will be really interesting to see how this line of cases continues to develop and what moves forward after this decision. I know we're still in early days.
Thanks, Joanne.
Thank you.
Thank you very much.